request now to kindly felicitate Mr. Tali Launcher, his Joint Director and Head of MSc Media, the Ministry of MSc. I would like to request Mr. Shanta Shivapalli to kindly felicitate. Yes, Shrivat Yusentla Younger, she is a Padma Shri Award to kindly felicitate. She is also the founder of Trademark and chairperson of ICC and Rules and Handicraft Committee. I would like to request Mr. Shanta Shivapalli to kindly felicitate the executive member from Business Association of Nagaland, which was PAN also, to kindly felicitate. Thank you so much for joining us. Now, without delay, we have one more speaker. She is Dr. B. Ganga. She is Assistant Professor from Innovation Ambassador, Ministry of Education and IT Nagaland. So, probably due to some traffic, she'll be here in another 10 minutes. Now, I request Shri Ishanta Shobhapalli to kindly extend your welcome address.
Respected Mr. Kekriover Kepitusa, pardon me for the pronunciation. Respected Srimati Santila Younger, respected Mr. Bentungo Kithan, respected Mr. Tony Longchar, respected friends, ladies and gentlemen, my media friends, a very good morning to all of you. At the outset, I would like to thank and welcome, especially Mr. Tali, Commissioner, for being here. In spite of their busy schedule, understanding the need of this program, they are here. Today, we have got a couple of young stars and young brains here, where it's very important for them to understand, for you all to understand the need of intellectual property rights. So I won't go in details about what is the intellectual property right. That we will come to know in the day to maybe in our other speakers when they speak. Just to give a brief view. Our creativities need to be protected somewhere. Suppose I have invented a small machine, a small equipment, a small design that need to be captured, that need to be protected, so that no one else in the world can use that. I have written a song, I have done a wonderful melody that need to be protected, that need to be stored. So this intellectual property rights is basically our inventions are protected through these laws. There are copyrights, there are patents, there are trademarks, there are industrial designs, there are GIs, geographical indicators. So basically, these are ways how we can protect it. In fact, this intellectual property right has started long back in it started way back in 1800s. Then, it means 1850s. Ipr Act was. People were not aware of it. I'll give a very recent example. The disadvantages or advantages of not having the intellectual property rights or for having the intellectual property rights registered. Very recently, so it's very interesting that one of our doctors from Assam, he is Mr. Dhoniram Bora. 25 years back, he has invented a process where a heart can be transplanted to a pig. A pig heart can be transplanted to a human being. And now, just because his research paper was not patented, he has suffered. Now it has gone to the year has gone to the Americans. So that's the advantage, that's the protection that we can have, we can get from the intellectual property rights. There are many songs, particularly the places are northeastern states, and so our songs, our melodies, we see that it's been taken up by maybe the Bollywood industry or the Hollywood industry people. If he has got a copyright, there are very interesting and very good policies, the act, as per the act, where we can be protected, we can get huge compensations for those things. We can sell those copyrights. Our inventions are protected. In the Chamber of Commerce, we have got an IPFC center, that is Intellectual Property Facilitation Center in Guwahati, where we have got a full-time attorney, where our attorney will be speaking virtually in a short while, where everyone can approach us in terms of copyrights, in terms of trademarks, in terms of patent. So that door is open. Earlier door that opened for doing a copyright, for doing a patent, to depend on or Delhi, or getting attorney itself. The current itself was a problem for the people of Northeast. Now that advantage is there, ICC has got a full-time office, full-fledged office in Nagaland. So we have been doing this patents for IIT Guwahati, the Manipur universities, and a couple of other places in the northeastern region. So it's important that we utilize the benefit from the IPFC center that we have got in Guwahati. Also, I must say that Government of India and this particular IPFC center, there are a couple of reimbursement policies where suppose there for a copyright, the cost is around 5,000 rupees, around 4,000 rupees will be reimbursed. So it's not that we are spending a hell lot of money for the copyrights or the trademarks. So we have got an advantage, but the only thing is we need to use. We need to know, understand what is the copyright, what is trademark, what is IPR policy, and we need to start protecting our inventions. So I got nothing much to say. We have got a very interesting technical session where our learned attorney will be speaking, Mr. P.K. Bakshi. We have our Deputy Controller, Mr. Parijat Saurabh will be joining us from Kolkata. He is from the Office of Controller General of Patent, Design and Trademarks. So we have lots of very interesting people joining here. We'll be having a very good learning session at the end of the day, and I'm sure we can take the benefit out of it and use it in the near future. Thank you very much. Thank you.
So much, Sri Shanti for your insightful. We have, before proceeding towards our next activity, I would like to introduce our the panelist who has joined virtually and also. I'd like to introduce Mr. Parijat Saurabh, Deputy Controller of the Patent and Design from the Office of Controller General of Patent Design and Trademarks from Kolkata. He has joined us virtually. Mr. Parijat, can we hear you?
Yeah, please. Good morning to all of you. I'm here well in my office, so please continue.
We welcome you, and we are actually missing your presence over here, but we are happy to have you virtually also. Thank you so much for being there.
Thank you.
We also have Mr. P.K. Bakshi, but unfortunately he has a hearing from 10:30. That is again virtual, so he'll be joining us by 11:45. We also have Dr. D. Ganga, Assistant Professor, Innovation Ambassador for Ministry of Education. She is from IIT Nagaland. May I request my colleague Siddharth to help us investigate her. May I request Mr. Shanta Shubhabandi to kindly felicitate Dr. D. Ganga, Assistant Professor. She's an Innovation Ambassador from the Ministry of Education and IT Nagaland. Thank you so much, Dr. Ganga. Thank you so much, Madam, for helping us. Now, may I request Shikali Lauja. He's a joint director and head of operations from MSME Development Department from Ministry of MSME Government of India. Thank you so much for that. May I kindly request you to kindly please give your attention. Please, over to you.
Good morning, everybody. Good morning. Our respected chairperson and our guests in the dais and prospective and industrialists, all the industrialists here to be. First of all, I welcome you in this national conference call because we are celebrating 2024, 75 years of Indian independence, Azadi Ka Amrit Mustafa. That's why we sponsored this program to disseminate with our fellow citizens in Nagaland. Because micro, small, medium enterprise minister is playing a vital role in India in economic development today. You see, India is exporting from MSME 49.5%, and employment generation is 10 crores. In this area, if you want to do business, if you want to develop your own idea, an innovative idea, design, everything, your copyright, you have to have knowledge, information, any activity you do, develop, we can do trademark registration, we can do GI. For example, in Nagaland, there are 17 tribes, 18 tribes like people are there. There are traditionally so many things, shawl, all the Makila, all these things are there. But in Nagaland, very few are registered GI tag. Only tomato, Naka tomato is registered. And Chisami, Chakisang, over there registered their home. Most of the people are not registered. If you register, your value addition will go up, your business will grow up. We are producing. But outside the people, designers, everything will come. They're collecting, they're adopting, they are collecting designs of you and they are selling in the other country as a J product. We are looking because we are looking IPR. Knowledge. That's why we want to give awareness. Our traditional products, so many things are there, like bamboo, woodcraft, shawl, towels, everything, bowl, baby doll also, you can do. So, in this era, government are giving you the chance for registration, and Ministry of MSME also giving you trademark, all these things, registration, GI, reimbursement schemes are there. So you can avail these schemes. But we have to have our own. First you spend the money, then you do the reimbursement. That is mutual understanding we have to do. Company is giving you the facility, but you do work first. Then you claim your share. That is the idea we are disseminating here by this conference. But industries, peoples in Nagaland, only 1% are doing this. Suppose I am doing a organic tea product, most of them are following organic tea product. Bamboo, they are following that one. Why? We have to develop our own idea in creativity to give to the market. Then only you will get the maximum profit. You can utilize your this Ipr schemes. That will give you more business growth. That is our theme. Our aim is to grow our business internationally, nationally. But when you get it hidden inside small bucket, your business will not grow. So we have to be broad-minded. We are ready to give tax also, income tax also, revenue, GST payment thereof. Then only you can improve your business. Most of the people in Nagaland are saying, we are not paying any tax. They are doing up to tax 99. Look at it. I'm not going income tax 99 only. If you earn salary, after activity you have to pay. So हम लोगों को क्या करना है? We should understand how to work, how to talk, work and talk, then grow your business. Now, there are so many schemes related to this. When you mix or join with the Indian Chamber of Commerce or ICICI or PhD Chamber of Commerce, Loko Uttar Bharati, all these are company people. Yeah, form a group of people and they are doing social service. To disseminate this work also, any activity and exposure trip also, when your company is registered, you can trade them and you can go for exposure trip also to know knowledge where it is market, where is the what technology is available. But when you do a proprietorship only, your business, you cannot trade with the Chamber of Commerce people. So we have to upgrade our micro to small and medium, then large. If we do that one, then our objective of fruit of MSME unit through Ipr, intellectual property rights, will achieve. In these few words, I welcome all of you and take the technical seasons very seriously because this is the time to learn. There is no age to learn anything. Everything you learn, till we go to 6th, 5th, that will give you a business group idea. Thank you.
Thank you so much. Thank you so much, Mr. Tani, for your detailed information about the MSMEs and the benefits. Now, we would like to request and invite Mr. B. Kathan, the executive member from Business Association of Nagas, which is also known as BAN, to Naga to kindly address your interview. Thank you so much.
Distinguished guests,
technical addresses. Ladies and gentlemen, greetings from the Business Association of Nagas. I take this privilege in thanking Indian Chamber of Commerce for organizing today's National Conference on Intellectual Property Rights under the theme Business Growth through IP Trends. In the framework of an international globalized market, fast technological changes and more demanding consumers, businesses need to look for further ways to differentiate their products and services from the competitors by improving their quality and technical characteristics, reducing production, distribution, and management costs, and offering value to consumers. Intellectual property rights enables you to protect that added value on your products and services and helps you build a sustained competitive advantage based on it. Thanks to your right to exclude third party from using or commercializing the protected products, or in other words, patents, trademarks, and copyrights, etc. There are many intellectual property tools that can be used in your businesses, regardless of your sector. It can be combined to provide a richer protection overall the aspects of your creation. Improved manufacturing processes can be protected by patents or trade secrets. The look or packaging can be protected by trademarks or industrial design rights. Your company logos or product name can be registered or as trademarked. The company's promotional pictures and videos can be protected by copyright. Trademarks, domain name, and geographical indication allow customers to link the quality and the reputation of the product of your company to your company. Many companies today build their reputation over their ability in willingness to innovate. In these cases, patent, utility models, and industrial design rights reinforces the innovative image of your company. Therefore, all intellectual property rights are relevant in building your products, services, reputation, and strengthen your market position. Strong and diversified IP portfolios are capable not only of increasing companies' products and service values, they also attract the interest of other enterprises wishing to cooperate with your company through license agreement, R&D agreements, or even joint ventures. Such collaborative relation may facilitate the possibility for owners to expand their businesses into new geographical areas or new technologies, or contribute to the establishment of a strategic partnership in related market. In today's context, intellectual property can be the fuel that a region needs, the fuel that can power a region's economic growth, a region's ability to harness, develop, and commercialize its collective and collaborative innovation. With this, I urge all participants who are seated here to take full advantage of today's session and see how you can protect your products, services, and take your business to the path of uniqueness. All the very best. Thank you.
Right. Thank you so much, Mr. Ketan, for your detail. Now, may I request Padma Shri Abadi Shilari Settlaya, who is also the chairperson of ICC from Northeast and Jubes and Handicraft Committee, and also the founder of Tribal Video in the Secret Service. Thank you so much. Over to you.
Mr. Chairman, Respected dignitaries, students, entrepreneurs, ladies and gentlemen, good morning. I am extremely honored and thank you, Indian Chamber of Commerce, for inviting me to be a part of this seminal national conference on awareness of IPR, which is organized by the Indian Chamber of Commerce and partnered by MSME Development Institute, Inventor, Ministry of MSME, to share a few thoughts on the relevance of IPR in today's world. IPR, as my fellow speakers have said before me, is a significant tool to protect an innovation getting infringed without the knowledge of the inventor. With the increase in the importance of IPR in any business, instances of intellectual property crimes have become part and parcel of the digitized era, sometimes even leading to the failure of businesses. And why that happens is because when there is too much of replication and copying of your product, and you have not registered and safeguarded your business, this definitely leads to failures. And so companies rely on adequate protection of their patents, as was mentioned earlier by the speaker, trademarks, copyrights, and geographical indicators of goods or GI. And while customers make use of IP, intellectual property, to ensure that they purchase secure and assured goods. So today, in a web-based world, strong IP protection is much more relevant as it has become comparatively simpler than ever to copy, replicate, reproduce any specific template, logo, or functionality. So in other words, let's look at IP as an asset, like in any other physical property that offers commercial benefits to businesses, which in turn drives economic growth and competitiveness. Therefore, to startups, MSMEs, it value enhances and is likely to attract investors when their ideas and services are patented and protected. Now, coming back to the Northeast scenario, in the Northeast, communities are the collective owners of a plethora of goods and intellectual heritage that holds tremendous potentials to be key drivers of rural economies and lend the impetus to impact state economies if GI tagged. And an earlier speaker had also mentioned about how our natural producers and our handlooms and handicrafts should be patented so that we reap the benefits of it. What is geographical indication or GI? It is a name or sign used on products which corresponds to a specific geographical location or origin. GIs are typically used for agricultural products, foodstuffs, wine and spirit drinks, handicrafts, handlooms, and industrial products. And in the Northeast region, we are, considerably bounded by these goods and values and assets. And in these valuable assets, if GI tagged, the opportunities are quite inexhaustible. For instance, Muga silk is one of the first products in the region to be GI tagged in 2007. And in the country, Darjeeling tea was tagged GI tagged in 2003. So in Nagaland, we have 3 products. One is the Naga Raja Mircha or Naga King Chili, the tree tomato or tomarillo, and the Chakisam male shawl. And it's these 3 products which are tagged, GI tagged in the state presently. Just recently, I think Assam, the famous Assamese lemon was GI tagged. So also the missing alcohol, spirit, which the local brew has also been GI tagged. And the same can be done for many of our traditional products. So because the Chakisam shawl was GI tagged and also along with it several other of their textiles, the Chakisam Women Welfare Society had slapped on a case on 1 or 2 designers in the recent past because of infringement on their designs and which were taken away and claimed as their own by these reputed designers. And so the Chakisam women have taken them to court, and I think till to date we are still waiting for the verdict. And the Chakisam shawl and the textile, because it was protected under the GI tag, the Nodal Women Organization was able to take them to court. So this is how important our, traditional heritage can be protected. Also, sometime in 2004, the Department of Industries, Government of Nagaland, had a mammoth exercise in trying to create awareness, and perhaps in the 3 days seminar that took place here in Dimapur, they tried to get all the women bohos together under one roof and get them to, identify their textiles which could be, set up for GI. I was a part of that exercise, but unfortunately, it was a very novel concept, and the importance perhaps of IPR had not, been instilled. And so everyone just went off from that seminar, the 3-day seminar, and nothing really much came out of it until in 2017, a good 12, 13 years later, the Chakisam Women Welfare Society is the first nodal women agency to have patented their shawls. And so this is a very encouraging thing for the rest of the Naga women bohos. I know that the Ao Watsimundam has already done a mammoth exercise in, bringing together, documenting all the shawls from every village, and I think shortly that information will be disseminated, and they are having a good mind to GI tag some of these shawls. And so I encourage young entrepreneurs present here of startups and future startups and MSMEs to back up the Prime Minister's vision for being vocal for local and thereby ignite Make in India sentiment. And I wish the conference all success. Thank you.
Thank you so much, Madam, for the words. Now, may I request our distinguished guest, Shri Devi, who is the Commissioner and Secretary from the Department of Industries and Commerce from Government of Nagaland. So, over to you.
Thank you, Pranjal. Very good morning to everyone here today. And let me also give an apology before I start for my lateness in arriving, and I kept all of you waiting. Unfortunately, I relied on my driver's memory and we took a wrong turn. We ended up somewhere else in Kenmore. I had to rely on Google Maps after that. And as we all know, the Google search algorithm is one of the best kept trade secrets, and it's absolutely tightly protected through patents. And so, along with the Coca-Cola recipe, I think those are some of the most famous IPRs kept secret. Now, I am here today as an interested participant and observer also, because I am also frankly very ignorant about intellectual property rights. I only have a layman's knowledge, and I am hopeful of learning more as the session goes. But I would just like to share one or two concerns and observations. Some of my fellow speakers have also raised issues, and I just want to expand on some of those points. Firstly, Tali, I really don't want to pay income tax. So we should pay income tax on that, but we do pay taxes elsewhere. So let's not go into that. But I know you raised your concern regarding the lack of IPR relating to our traditional wear and designs, and Madam has also spoken on that. So let me just say that the Department of Industries and Commerce, particularly the Nagaland Handloom and Handicraft Development Corporation, have just recently been given the mandate to collect and record all the information related to traditional handloom and traditional wear and jewelry, with an idea that all this information will be collected, and with the intention of getting them GI tagged. So that is something that we will be starting this year, and hopefully we can come to a conclusion early. I know it's going to be a very huge task, and I know a lot of resources are going to go there, but this needs to be done. As Madam has said, the department earlier tried to do something on this, but I think at that time awareness was not there, and not just awareness, but also the importance of why these need to be protected. Because when we talk about intellectual property rights, firstly we start thinking in terms of patents for inventions. Maybe we talk about copyrights for literary or artistic or musical works, or some, what we call industrial designs. I have spoken about trade secrets. But in our context, it's also very important for us that our traditional practices and our traditional expressions, what we call traditional cultural expressions, need to be protected, and that is why where GI tagging, also geographical indications, they play a big role. And in our context, I think that this needs to be done first. And I am very grateful to the Indian Chamber of Commerce for organizing this national conference. I think this conversation needs to be held more frequently, and also, it needs to be held, with a wider audience also. Because as we have seen, there have been a few controversies regarding the GI tag products of Nagaland earlier, and our speaker, Madam, has alluded to them also. We know about the Chekasang Women's Welfare Society case against Ritu Berry, firstly, and I think it was TriFed. So there are some issues that come up. One is that whether the rights conferred by GI were abused or taken out of context. So in that sense, yes, it should have been, because the male shawl was modeled by women. But in a wider context, GI also ceases, the protection offered by GI ceases, as far as I know, once the product has been purchased legally. So I don't know whether the protections offered by GI can truly protect us. Maybe we need to go beyond the present protections that have been given. I hope that some of these issues will also be discussed by experts later on, or maybe in future we can have discussions on these. Secondly, I think a few months back there was a lot of joy regarding the GI tagging that was received for Nala sweet cucumber. But at the same time, there were a lot of criticisms also that why the applicant and the right was conferred to Neramak, right? Neramak. I think the full form is Northeastern, yeah, I think marketing something. So in the end, I think, whereas you know that it was fully supported by the Department of Agriculture or Horticulture, I think. But in the end, probably it might have been ignorance on the part of government departments at the time when the application was processed. So that's why I say awareness firstly, and then the expertise also needs to be developed to process our applications, our claims for patents and for GI tagging, because it's something that an individual cannot do. It's something that organizations themselves will find very difficult to do. And for that, you can do it as private individuals also, but it takes, I wouldn't say it takes a lot of money, because the process itself is not very, I mean, the fees themselves are not very expensive, but you need to spend a lot of time and energy pursuing these cases. And for getting the GI tagging itself, it's a Herculean task, because the documentation is so exhaustive. I don't think any individual can do it within any reasonable period of time. So that's where government departments come in, and that's where these issues of awareness and expertise come in. So thank you once again, ICC, for organizing these. I hope that we can all learn from here, and locally also, without any external prodding also, I think organizations like BAN can also carry this conversation forward. I look forward to hearing more from the expert panelists involved, and also from fellow panelists that are yet to speak. And thank you once again, and thank you for attending this conference also, and I hope all of us will take back some positive information from here. Thank you so much.
Thank you very much, sir. Now, may I request Dr. D. Ganga, who is Assistant Professor from Inventions Master and Ministry of Education, and Madras. We'll start with the technical session without delaying. Our topic is basically technology development, which is an introduction to the future growth. Thank you so much, Dr. Ganga. Yes, please go ahead.
Very delighted and good morning to all the dignitaries here, participants. The organizer, the ministry, the MSME Development Institute. So I'm really glad to represent MIT Nagaland in this August forum and to deliver a talk on technology development for future growth. In this conference of business growth through industry, right? So my earlier experience with Remedies gave you a lot of introduction about the importance of registering and intellectual property. So I think later also you will have a lot of many learning sessions related to all the processes involved there. Now I take this opportunity to discuss with you about the role of technology in developing an intellectual property. Because unless we have the intellectual property, we cannot register, we cannot have any registration, we cannot claim any API, right? Intellectual property rights. So from where does this intellectual property come from? It comes from innovation. From where the innovation comes from institutes, right? So education institutes play a major role in bringing innovation. So unlike before, now education is moving into a new dimension with new teaching learning processes, new evaluation process, and also about new product development processes. So the education system, that is what our new education policy also tells about it. So the education system itself is going through a huge amount of transformation to suit to the present current technology, because earlier education, the methodology is what will not be suitable anymore. That is why we are reviving the education policy implemented. So the education is moving towards a new dimension with the objective of encouraging innovation and also to encourage the students to have entrepreneurship skills and to start new upcoming startups. So this is how the education is moving towards now. And of course, ultimately the objective of education itself is now presently moving towards achieving the objective of innovation and self-reliant nation, Atmanirbhar Bharat. So this is what we are speaking about right now. So, as the innovation gets strengthened, the technology also gets strengthened. So this is the condition. Because from the earlier days, if you see, earlier we have been having industry 4.0 technology. Now we are in most industry 4.0 is also over during this pandemic. Now we are entering into the industry 5.0. We are entering into the industry 1.0 where we have a lot of technologies with Internet of Things, artificial intelligence, and more smart technologies, 5G communication. Even 5G is also, whether we have implemented 5G or not, that is also a question. Even now we have entered into the 6th generation of communication. So earlier we were in industry 1.0 where mechanization process started instead of human work has been replaced with mechanization. And now we are witnessing industry 4th revolution is over and we are witnessing the 5th revolution, industrial revolution. Earlier, if you see, there were ordinary bulbs that were used in the house. Now we are using smart bulbs, right? So earlier we had telephones. Now we are having smartphones. So the entire world comes in our hands. And similarly, earlier with respect to the entertainment industry, if you see about the entertainment industry, you would be looking for the 3D pictures with a lot of interest. But now we are moving into the field of virtual reality and augmented reality, where we ourselves experience, can have virtual experience in the real life, and also we can bring the real life into a virtual world. That is how the gaming, all the new games are coming up. And not only games, it is not restricted to games. This virtual reality and augmented reality is coming up in a lot of scale, right from the civil engineering to all kinds of engineering is going on. So in this way, the artificial intelligence technology, the smart technologies are entering into our day-to-day life. And one more, even when we talk about sound waves, we always say that we can hear sound. But nowadays we started saying we can see sound, that is semantics. So in semantics, they say that you can visualize your audio waves. So we are entering into the technology where there is a complete transformation with more intelligence embedded into it. Earlier we have been using physical systems, but now physical systems controlled by engineers or technicians or anybody. But now the physical systems are designed by humans with cognition there, with intelligence embedded there. So this is how we are moving into. So in this technologically advanced scenario, so how does all these come? How does all these come? Only through innovation. So without innovation, there is no technology development. So as the innovation gets strengthened, the technology also gets strengthened. So the role of education institute is quite different. That is why we are moving to a new dimension of education. That's the reason we are having new education policy. But if you see the new education policy, we can witness a lot of changes there in terms of flexible credit systems, in terms of changes in the teaching learning process, in terms of product development, in terms of the requirements that are set for getting a degree. So this is how it is going. It is getting into the industry institute collaboration. It's not going to be so hereafter academia is not going to be only teaching learning. It's going to be something else. It is going to be application oriented. So educational institutes have the biggest responsibility, the responsibility to prepare the students, to prepare the students to develop innovative products, to bring innovation in their studies. So how to achieve that? As I told, the way in which education is being, the framework is being changed, but that alone is not sufficient. Whatever that is written in paper, that could stay for long. But if you want to have something executed, we have to enter into the ground. So one of the ways is Ministry of Education has one of the ways that is being implemented right now is Ministry of Education has formed a MOE's innovation cell, whose target is to encourage. This is not the theoretical thing, I'm telling the practical thing that is getting executed right now. So the Ministry of Education has an MOE innovation cell, which is MIC, Cell of Council. And the objective of the MIC is to foster innovation, strengthen entrepreneurship skills, and encourage the students to develop products and to support them in IP, intellectual property rights, and also to promote the prototypes, what they have developed to the markets. So the MIC has this one as the objective, right from your idea to the product marketing. It's not only about the product creation, it's not about product manufacturing. Whatever product you are doing, that they're also helping in marketing the products. So this is how they are doing. So how it started is, it started with like how they are also part of that. How it is getting implemented is MIC is training. It's not I should not say it. MIC is training the Institute Innovation Council. MIC asks every education institute to start an Institute Innovation Council, and they train the members of the Institute Innovation Council of every education institute, not only it's a central government institute, all the institutes, state government institutes also they emphasize that to mandatorily have the institute, even in your colleges also, you are eligible. If you are not, you can also spread the information to your college to start an institute innovation council where the activities are planned in such a way that the students are trained to think innovatively. So design thinking, critical thinking. So thinking is very important. Ideation process. So the design thinking, critical thinking, ideation, and once the idea is ready, you have to make it as a prototype. Once the prototype is ready, you have to test in the market. Once it is tested, you have to market it, right? So commercialize, you have to do that one. So the Institute Innovation Council, thus, the role of Institute Innovation Council is to execute all these activities. So once these activities are executed, of course, we need to have some outcomes to see, to evaluate about the process, what the time is very precious. So that evaluation process is in your hands, is in the hands of the students. Means the evaluation process to get succeeded, we need outcome there. So taking this as a platform, and I would like to express my wishes here. NIT Nagaland also has an Institute Innovation Council. So NIT Nagaland also, we have a lot of good infrastructure there. And we also have a strong desire to bring innovation, to execute all these activities from ideation to product development to marketing. So to execute all these, we have students, but with only one hand, we cannot, with only one hand, we cannot do this. All right, we need two hands. So I take this forum to invite all the relevant agencies, organizations, like MSc, so I heard from everyone. So I request all the organizations related to innovation, entrepreneurship, startups, incubation, to collaborate with NIT Nagaland, to join hands with NIT Nagaland, so that not only the student community gets benefited, but the entire societal community inside Nagaland gets benefited. Because one of the advantages, of course, like I heard from all the speakers about the specific technical items of Nagaland, like stalls were spoken much, maybe Raza Hachi was spoken, bamboo shoot was spoken much. So all these are unique products, but how to market, how to take these products to a global level. So for that, you have to integrate those products with smart technologies. Once you integrate, what is happening? Earlier we had mobile phone with keypads. Now we are having the same mobile phone with touch screen. That's all. Earlier we had computers with separate Ethernet port. Now we are having we are having Wi-Fi. So it is about idea of integrating multiple technologies. So apart from ethnic items, there are a lot of scopes. In addition to ethnic items, which are unique in the entire country, in addition to that, there are a lot of scopes inside Nagaland specifically or inside the office, because I'll tell you the risks in other states. The risks in other states is they are almost like not either completely developed and or not underdeveloped. They have some systems established there. So in those systems to integrate the new technologies, if something is there, some infrastructure is there, and if you want to transform the existing infrastructure to meet the 60, to meet the smart technologies, it's not so easy. It takes a lot of, it will take a lot of energy, money, energy, cost, everything. But in contrast to that, if you see in Nagaland and many of the Northeast states, it's open. So the technology, so the establishment of technology here will be much easier than the establishment of those technologies there. So this is the real scenario. right from your, you can take any kind of sectors, right from water, you can take water industry, water supply management, smart city management, agriculture, and bamboo shoots, and as I told you, we have a lot of specific, unique items here. But how it's like those items you can have as an element. But in addition to that, include all these smart technologies there. Then we have a unique market there. We have a unique market in the global economy. So that's the specialty here. So there are a lot of openings there. So I invite, and we are also interested. Yeah, in Ireland, we have a lot, again, in existing, we have a lot of infrastructure, we have a lot of students there, we have potential there, but we need the openness. We need to know how to expand all these technologies for the development of the state, for the development of the place where the institute is there. The purpose of establishing a national institute, establishing an institute of national importance is not only to give education for students, because students may get educated and go outside and get placed. That is not the only task, only the objective. It is also to develop the society there. So those things are possible only with the help of all the organizations inside the Ireland. So I request all the organizations taking this work to extend their support in terms of collaboration, in terms of MOU or any kind of assistance. We can do it. And I invite all the participants, if anybody is interested, you can always discuss with all the faculty members in the potential research areas where we have potential labs there. You can really start the innovation practically rather than speaking in meetings and writing the papers. You have to do it. And we should have a lot of MSME, a lot of business here. Of course, it's possible and it's open and easy. It's an easy tool. Only because you have to develop the skills. So to develop the skills, only we are there. We are there to extend all kinds of facilities, all kinds of knowledge transfer. Everything is possible. So I think we can realize that in future, I guess. So with this, I would like to thank ICC, Regional Director ICC for giving consent to sign the MOU with NIT Nagaland, which is the first step and first thing. Similarly, I request other person. Thanks a lot for giving me this opportunity, and I was very when I heard from Sir about this conference, I was very glad because I was also looking for the forums to get the right kind of associations. So I thank you all. I invite you to NIT Nagaland, and let's work together to get a new Nagaland, right? Thank you very much.
So much, Dr. Ganga. In that, we will definitely after the MOU, we will have full-fledged support from our IPFC center. So, in short, with technology, we encourage startups and we will protect with all the IP rights, basically under the leadership of IP and the right. Again, thank you so much for your presence. Now, the main technical session, which we are talking about actual IP rights, what is IP right, and the importance of these IP rights. So, to start with, we have a special guest who is joining us virtually from Kolkata. He is Mr. Parijat Saurabh, Deputy Controller of Patent and Design. He is from Office of Controller General of Patents, Design and Trademarks. It's basically the topic is on overview of intellectual property rights. Mr. Saurabh, can you hear us? Is it audible to you?
Very good morning. Very good morning. Ranjal, very good morning.
Yes.
Can you hear my voice?
Absolutely. Yes.
So, very good morning to all the distinguished guests, ladies and gentlemen. and the organizers ICC. It's my privilege to be part of your program, and I am feeling honored to share my experience and all the events of the intellectual property right of the Patent Office. So once again, thank you, Pranjal, and to ICC. So we are going to begin this slideshow. So actually, this is a part of our intellectual property awareness mission NIPAM, which is a part of our 75 years of our Azadi Ka Amrit Mahotsav. So I welcome all of you once again to be part of this program. So let me begin with the slideshow, which covers the entire aspects of intellectual property right, like patent, designs, trademark, copyright, GIR, and SICLD. So gradually we will see how this functions in our system. And if you have, any one of you have any question, you are free to ask. Yeah. So now beginning with the intellectual property rights aspects, first part contains the patents, which is for an invention of a product or process. Then is a design, which is given for a shape, configuration, pattern, ornament, or composition of lines or color applied to any article. Then contains the trademarks, which is a sign of capable of distinguishing the goods or services of an enterprises from others. Then comes the geographical indications, which are given protection for any product that have a specific geographical origin and possesses qualities or a reputation. I think a few of our distinguished guests had been speaking over the GI products, which we'll see in details after a few slides. Then comes the copyright, which is given for protection for a literary and artistic works. Then comes the semiconductor integrated circuits and layout designs. Now coming to what is actually the IPR, how you can distinguish the different kinds of IPR in a single product. Now let me give you an example, like this MacBook. Now the MacBook contains a symbol of an apple. Now this apple symbol is a part of design, or it is a part of a trademark. Then comes the LED display, which is a part of patent. Then Apple sign is a part of trademark, user manual is a part of copyright, and layout of IC is a SICLD design. Now a single product contains several aspects of IPR, and this IPR have different protections which are given by the Government of India. Now what actually comprises the intellectual property rights? It is the combination of brain, resources, labor, and all this gives rise to or gives product as intellectual property. Now, what is the importance and significance? First thing is that the government gives the protection to inventor. Then this is an exclusive right which excludes others from giving this right to anybody else without the permission. And third aspect is the utilization of commercial utilization for earning money. Now, this is a matrix, how the earning starts by use of own use, license or assignment, merchandising the product or franchising. These are the 4 ways by which an inventor or patentee can earn the money. Is it okay? Pranjal, are we going okay?
Yeah. Go ahead.
So how a common person and businessman sees intellectual property? A common person sees this as a part of right and is a part of academics. Like Madam was saying that if it is a part of academics, you can get a point over PhD or your own, the academic excellence. As a businessman, this is utilized as a part of commercial value, as a brand value, and earn an investment. Now coming to this patent part, what is actually patent? A patent is a statutory right for an invention granted for a limited period of time to the patentee by the government in exchange of full disclosures of his invention for excluding others from making, using, selling, importing the patented product or process. Now, earlier slides we had seen that this is the exclusive right. Now, what is the meaning of exclusive right? that without the permission of a patentee, nobody can produce or utilize that product without his permission. So this is exclusion. So, there is also a legal right to exclude others from using your invention. Without the legal permission, nobody can utilize your product or the process for which you have been granted a patent. No concept of global patent. It is a highly regional in nature. A patent granted in India is applicable to India itself, though the invention might cover the entire world. Tenure of patent is 20 years from the date of filing of application. So these are some of the aspects which covers inside the patent. Now, famous inventor and inventions, you see the photographs of George Alfred Depenning, a civil engineer of Calcutta, petitioned the government of India for a grant of exclusive privilege for invention, an invention Pankha pulling machine. You see he was probably the earliest inventor for this Pankha pulling machine, and you can see the left hand design of that Pankha pulling machine. So this invention was granted, a patent was granted to Alfred Depenning. Now, scientists who were involved with the different popular inventions, they were Thomas Alva Edison for phonograph, Alexander Graham Bell for telephone, Wright brothers for aeroplane, Louis Pasteur for rabies vaccination, Alexander Fleming for penicillin. These are some of the famous Indian inventors who had invented this product and got the patents. A nano car, it is at $205,000 from Tata's for providing an opportunity for medical income families. Then hepatitis vaccines, 40 cents a dose. This was the patent was granted for this vaccine. Jaipur food, affordable prosthetics at the rate of US $28. So these are some of the Indian inventors. So these are the kinds of patents where it has been granted, like this head kept over is a kind of hat which prevents from rainfall. Then a hand, you can say user interface, then swipe machine, then drone. All right. So patent application filing. This is a technical part where how to file an application. This we are going to show here. What actually is required by filing a patent application. First thing is required is Form 1. Details, which Form 1 contains the details of application, applicant, and fees is required to be paid accordingly as per MSME, or you are a university or individual or a company. So different fees schedules are also given in our website that we will see later on. Now the second part contains the Form 2. Form 2 contains the details of invention, which contains the title, background of invention, particulars of drawings, brief description of drawing, brief description of the invention, claims, abstract drawings, fees not required for 30 pages and 10 claims. Now, once you file a patent application, the Form 2 contains the actual gist of the invention. For the first 30 pages, you don't require to pay any extra fees. And for the first 10 claims, you don't require to pay any fees. Now, coming to the Form 3, Form 3 actually contains the details of foreign filings, which have been filed apart from India. Fees is not required to be filed here. But for certain international applications, it has to be filed within 6 months. Now, Form 5, this declaration as to inventorship. For this also fees is not required. Then comes the Form 18, the request for examination. For every application, you have to make a request. Then only the examination will start. For this, you need to pay a fees. Now, these are the different formats of fees payment. Form 1, it is for natural person or a startup or a small entity or educational institute, it is just 1,600. For other than natural persons like company, it is 8,000. For Form 2, for 30 pages and 10 pages, you don't require to pay any fees. Form 3 and Form 5 don't require any fees. Form 18 is a kind of request where 4,000 is required for natural person or small entity and 20,000 for a company. Now, total comes to 5,600 for a natural person or educational institute and 28,000 for a company. Okay, all right. Now, filing procedure is submission of hard copy in the appropriate patent office, But this is not required for, this is not a route to be followed by patent agents. If you are filing through patent agents, only the portal is there, e-filing is required to be filed. Now, online filing, e-comprehensive file through portal, and the address is given is this. For the patent agents, you require a digital signature for class 2 and class 3 signature. This is a comprehensive e-filing portal which needs to be logged in with the details. Now, there is another provision where the government of India has introduced. This is called expedited examination. This expedited examination is meant for a startup, small entity, applicant is a female or a joint applicant with other natural persons, department of the government and other government establishments. India has a ISA, IPA in PCT, an agreement between Indian Patent Office and a foreign patent office. Now, these are the criteria. If any applicant comes under this expedited examination, they have to fulfill this criteria. So expedited examination, just after the 18 months, your application will get for examination, start for examination. Now, this is the patent application processing. So this is a flow chart which you can see how the application process is filed. Application processing is done in patent office. There are three kinds of application like PCT, convention, and ordinary application. Ordinary application contains the provisional, which is filed up to 12 months. Then within 12 months, you have to file a complete specification. And then application is published after the expiry of 18 months. So these are the steps where examination is done. And then it is put up for search. Then for FER is issued. And then hearing and disposal, that is meant for grant and rejection. Screening and classification. Once the application is filed, there are various subject matter which are not allowable by the government of India. Now, it may be related with atomic energy, may be related with defense. Now, once the screening is done, if the application is found that it attracts section 4 or section 35 that is related with atomic energy or defense, it is sent to the examination for the DRDO or the atomic energy so that they can give their consent whether it can be moved or not for examination. So this is a examination process which where examination contains the formal and technical examination. First examination is being sent, which contains the gist of objections. Examination reply is again received by the patent office, where the applicant on the basis of the different objections, they reply back. If it is found contravention to the examination of the examiner, then hearing is conducted. And then after that hearing, grant or refusal takes place. So this is how the technical examination goes on. Read and understand the invention in relation with the drawing. Search for related earlier publication citations in the worldwide database. This is where the applicant needs to pay attention, where if any invention is about to be filed in patent office, you first make your own searches by use of the different databases worldwide. Check for novelty and inventive step with respect to the citations, and the detailed examination report is prepared. So these are the basic timelines. Provisional to complete specification is filed within 12 months. Request for examination is filed up to 48 months. Reply to FER has to be given within 6 months. Form 3 has to be filed within 6 months. Form 5 within 1 month. Withdrawal of application within 15 months. Hearing submission 15 days. Pre-grant opposition before grant, and post-grant opposition within 1 year. So these are the different aspects where the examination is being conducted. Now we have come up to the slideshow of patent part. Any question I would like to hear from all of you regarding this patent part, because we will be now moving to the design part. Pranjal, just ask any question here regarding the patent part.
Any question, any concern, we have this two-way communication, so you can anyone. I think request
We can proceed with the design part.
yes, yes. We can proceed.
Okay. Okay. Thank you. At the last also we can take up the questions. No problem. So now coming to the industrial design. So what constitutes the designs? Designs means only the features of shape, configuration, pattern, ornament or composition of lines or color applied to any article, whether in 2-dimension or 3-dimension or in both, by any industrial process or means, whether manual, mechanical or chemical separated or combined, which in finished article appeal to and are judged solely by the eye. So actually design means whatever the configuration, outer configuration you are being seen, which constitutes the article, it has to come under the definition of article. It may be any industrial process or means, but does not include any mode or principle of construction or anything which is in substance a mere mechanical device, and does not include any trademark as defined in clause this and this of the Trademark and Merchandise Act. Now, term of design is for 10 years. It is extended up to 15 years by extension of 5 years. You can see the sample of industrial design for the car. Now, definitions as the article section 2A says for the design part, article means any article of manufacture and substance artificial or partly artificial and partly natural, and includes any part of article capable of being made and solely separated. So we can see the definition here itself says that it has to be any substance which is artificial or partly artificial. Then the original part in relation to a design means originating from the author of such design, and includes a case where though old and in themselves and are yet new in their application. So it means that the design may be very old, but the application is presented in a new way. So these are some of the patterns of design of an article, like the sofa, this trolley bags, watch, bicycle, then car, and then spray bottles or the masks.
विशाल का और कोई कॉल उल कुछ तो है नहीं ना, ये केयरलेस है, एकदम इसको लगता है कि चलता है, कुछ मनवा लेंगे.
So these are the set of articles. So design doesn't only mean that only one article has to be there. So set of articles also constitute set of is a design, comes under design. So set means a number of articles of the same general character ordinarily sold together or intended to be used together. So you can see the different constituents of articles. It is a cup, plate, and then the jug also, which constitutes article. So it is a set of articles. These are the designs of set of articles, like the jewelry sets, cup plate sets, and the sofa sets. So they are all under the pattern of design, and they are registrable, provided they comes under the definition of design. So filing of design application. So here also electronic filing is being done. Physical filing is being done at Delhi, Mumbai, Chennai, and Kolkata, and all the digitization part and examination part is done under at the Patent Office, Kolkata. We have got a different design section here, where all the processing of the design application is being done. For physical filing, demand draft in favor of controller of designs payable at Kolkata has to be given. Now, requirement to file an ordinary application. Now, application fees contains rupees 1,000 for small entities, startups, or individual, and 4,000 for others. What are the constituents of this application? It contains Form 1, which where it should include the applicant's full name, nationality, address, priority data, priority registration data, signature and date. 2 sets of representation illustrating various views of article has to be given. I mean 2 sets of photograph. Now, power of attorney, if required, if it is filed by some other attorneys, the power of attorney is required. Assignment document is required, and Form 24 for small entity and startups. So this is a specimen of representation sheet. This was actually an application was filed for the design, and you can see this is the overview of this design application. This is a perspective view of a I think kettle set. You can see this innovative set, teapot. And this is the design certificate which is issued once it is registered. You can see the format of design registration certificate. So publication, all the design applications which are filed, they are published in Patent Office Journal, and you can see the details of the format of the journal publication, which contains the design number, class under which it is filed, address of the applicant, date of registration, the title, and if there is any priority data, then it contains. And right side contains the design article. So before delivery of sale or any article to which design registration is applied, each article to be marked with registered or REGD or RD. You will see any article which is already registered under design. You can see this logo REGD or RD. So it means that the design is already registered, and this may deter potential infringement and help in legal action. So anybody who is utilizing without the consent of the applicant the article having RD mark or REGD mark, it is a potential infringement and legal action might initiate. Now, importance timeline for ordinary application for design application. So first examination has to be filed within 6 months from the date of filing. Within that 6 months can be extended up to 3 months. Term of design is for 10 years from the date of filing. So request for renewal has to be filed within 10 years. A request for restoration of last design to be filed within 1 year from the date of cessation. So we have come up to the design part, which covers the definition of design, how the application is filed, what are the design legal and the formal aspects. Now coming to this trademark part, what actually is trademarks? It is a concept. So trademark is any word, name, symbol, or device, or any combination thereof. It identifies and distinguishes the source of the goods or services of one trader from the others. The definition itself is very much clear that what should the trademark should contain. Then the functional importance is it provides exclusive monopoly over a class of goods or services, allows a business entity to build a public goodwill and brand reputation, identifies the source, origin of goods or services, assures customers about quality of goods or services. Just let me give an example. If you see the brand Tata, automatically what comes to you? It comes that it is a very good quality product, or it has a brand name, and the class is very of high quality materials will be provided once the Tata brand is there. So this is the advantage of brand. So these are some of the trademarks. This trademark includes the service marks, trade names, collective marks, certification marks, tagline, slogan, shapes, and sound marks. These are the components of a trademark product. This might contain the service, trade names, collective marks. So right side, you can see this M, McDowell, Coca-Cola, Columbia, Adidas, Google. So these are some of the brand names, and these marks are already registered. Coming to a good mark, good trademark. So what does a good trademark means? So it should contain distinctiveness, which should be inherent or acquired, not deceptively similar, honestly adopted, coined, not similar to already existing mark. You know, many of you must have come across the different brand names, and the similar brand names and duplicate products are made somewhere, like the Godrej. Now, Godrej word contains the Godrej. Now, this deceptive mark contains the Gordej. So it appears that it is a Godrej, but the actual word is already one word is already used there. So this is a deceptive mark, which is not the actual Godrej word. So like similar different varieties of deceptive marks are already in the market. So how to indicate your trademark? So once an application is filed, so that contains the word TM. It means that the application is under registration and application is pending for registration. So once the application is registered, you will get the mark R over the right corner of that slogan or the any tagline or the word. So R word means it is already registered. So how to protect your trademark? So trademark registration is optional. However, registration has certain advantages. Registration available to the national, regional or international level. Initially registered for 10 years, but can be renewed indefinitely for 10 years each time and so on. In case of non-use, non-renewal or non-policing, trademark rights are lost. So if you are not, suppose that you have got a trademark from the trademark office, and if you are not utilizing it, not renewing it, so naturally that right will be lost. The existing trademark registration is governed by the Trademarks Act 99 and the Trademark Rules 2017. For more information, you can visit this ipindia.gov.in, where all informations are available. This, we have come up to the end of trademark portion. Coming to the copyright. So what is copyright? Copyright is a right given by the law to creators of literary, dramatic, musical and artistic works and procedures of cinematographic films and sound recordings. It is a bundle of rights which includes the rights of reproduction, communication to the public, adaptation and translation of the work. Copyright does not ordinarily protect titles by themselves or names. Short word combinations, slogans, short phrases, methods and plots are factual information. Copyright lasts for 60 years. Original literary, dramatic, musical and artistic works, the 60-year period is counted from the year following the death of the author. Cinematograph films, sound recording, photographs, posthumous publications, anonymous and pseudo-anonymous publications, works of government and for works of international organizations, the 60-year period is counted from the date of publication. So in all these forms, 60 years from the date of publication, it is counted. So it comes to the lifelong or to the life plus 60 years. This is the actual calculation for the copyright right. Now, term of protection, published literary, dramatic, artistic and musical works, that comes to the life of author plus 60 years. For cinematographic film and sound recording, 60 years from the date of publication. So you can see that different rights under copyright, for the number of years they are given the protection. For broadcast reproduction rights, 25 years from the year following the year of broadcast, and performance rights 50 years from the year following the year in which the performance is made. These are the features of Copyright Act 1957. Provisions related to Copyright Office and registration of copyright, that comes under Chapter 2 and all those. The legal provisions are there. Provisions of statutory and compulsory licensing of works. So this compulsory licensing this contains the program software part also, which doesn't come under the patent part. So that licensing covers the software part also. Now the copyright provisions related to the rights of owner of copyright and tenure of protection. These are some of the features related with broadcasting rights. Then provisions related to the infringement and remedies. Subject matter of copyright, you can see the literary works, artistic works, and the corresponding sections which cover this copyright portion, dramatic works, musical works, sound recording, and cinematographic films. So who all are the authors of the work? Type of work is suppose the literary or dramatic work, then the author is the author itself. Musical work, music composer. Artistic work other than a photograph, artist. Photograph then contains the person who is taking the photograph. A cinematographic film, a sound recording, the producer is the author. For the literary, dramatic, and musical and artistic work, which is computer generated, the person who causes the work to be created. So the first is the type of work, and then the second is the author and the owner of the copyright. So copyright contains the two the parts, economic rights and moral rights. So economic rights are transferable rights, and moral rights, they cannot be transferred. They remain with the original author. A scope of economic rights, that is the reproduction right, distribution right, right to create derivative works, and right of communication to public, and right of public performance. So these are the where you can generate money. That is why it comes under the economic right. Scope of moral rights, right against distortion, that is called the integrity, and right of recognition, that is the authorship or paternity right. So application procedure, here also a very simple process is there to file a copyright application. Form 14 is there. Every such application can be filed in the Copyright Office by person or by post or by e-filing facility. So here also e-filing facility is there. Payment can be made in the form of payment gateway, DD or IPO. Now examination of application. So prescribed fees, corresponding prescribed fees is there for literary, dramatic, artistic and musical work, 500 rupees. For artistic work, for capable of being used on goods and services, 2,000 rupees. Sound recording, 2,000 rupees. Cinematograph films, 5,000 rupees. So we have come up to the end of this copyright portion. Now SICLD, that is Semiconductor Integrated Circuit Layout Design. So this semiconductor integrated circuit means a product having transistors and other circuitry elements in separable form on an inside or semiconductor or insulating material designed to perform an electronic circuitry function. You know, you must have seen the different very complex IC circuits inside our computer or the hardware. So all these combinations of circuits and transistors, they form together SICLD. So these are the definitions how we can form a SICLD, and you can get a protection for a period of 10 years from the date of filing of application. These are the processing and uses. You can see the right hand side, the design of a IC circuit. And this is a flow chart how the application process is filed and the certificate is issued, and the corresponding fees. Now we are coming to the geographical indications. There is one video here, please keep.
चिंदी चोर के साथ घमासान के बाद अब आईपी नानी बिजी हो गई अपनी पोती की शादी की तैयारियों में। संगीत वाले दिन जब छोटू उनसे मिला तो
वाओ नानी, आप तो बिल्कुल छाए हुए हो। आपके सामने तो मधुबाला को भी कॉम्प्लेक्स हो जाए।
ओए, मस्का लगाना बंद कर। ये बता तुझे क्या चाहिए?
नानी, आपने तो मेरा दिल ही तोड़ दिया। क्या एक प्यारा सा लाडला सा बच्चा अपने नानी को कॉम्प्लीमेंट भी नहीं दे सकता?
अच्छा चल, एक्सेप्ट किया तेरा कॉम्प्लीमेंट। अब बता तुझे क्या चाहिए?
मुझे कुछ नहीं चाहिए, बस आपकी हाथ की वो स्पेशल वाली चाय पीनी है।
बस इतनी सी बात के लिए इतना बड़ा मस्का?
मस्का नहीं नानी, आप आज सचमुच बहुत ही रॉकिंग लग रही हो। ये साड़ी आप पर बहुत ही अच्छी लग रही है।
अरे ये तो स्पेशल लखनवी चिकनकारी है। लखनवी चिकनकारी पूरी दुनिया में मशहूर है। ये अपनी खूबसूरत और बारीक एम्ब्रॉयडरी के काम के लिए फेमस है। लेकिन पता है इसकी सबसे बड़ी खासियत क्या है?
क्या है?
ये एक रजिस्टर्ड जीआई है।
जीआई? वो क्या होता है नानी?
जीआई का मतलब होता है जियोग्राफिकल इंडिकेशंस, हिंदी में जिसे भौगोलिक उपदर्शन कहते हैं। ये किसी समुदाय का बौद्धिक अधिकार है, वो विरासत जिन्हें प्रोटेक्ट और एनकरेज करने की बहुत आवश्यकता है। मुख्यतः इन टाइप्स में रजिस्टर्ड होती है: नेचुरल गुड्स, मैन्युफैक्चर्ड गुड्स, टेक्सटाइल्स, हैंडीक्राफ्ट्स, फूड स्टफ।
अच्छा।
चल अब ना किचन में चलते हैं और गर्मा गर्म चाय बनाते हैं।
हाँ हाँ हाँ।
किचन की ओर जाते हुए नानी ने छोटू को अपना देश घुमा दिया।
छोटू,
जी नानी।
ये देख, ये पेंटिंग देख। ये एक मधुबनी पेंटिंग है, बिहार की। और ये है हिमाचल की कांगड़ा पेंटिंग। तेरे नानू को देश की कला और संस्कृति से जुड़ी हुई चीजों को इकट्ठा करने का बहुत शौक है।
अच्छा,
ये कठपुतलियाँ देख रहा है?
हाँ।
ये राजस्थान की हैं। इसी तरह छत्तीसगढ़ से बस्तर ढोकरा, आंध्र प्रदेश से तिरुपति लड्डू, असम से मूगा सिल्क, नागालैंड से नागा मिर्च और मध्य प्रदेश के बाघ प्रिंट, ये सब रजिस्टर्ड जीआईज हैं।
ओके।
ये हमारे देश की कला और संस्कृति का प्रतीक हैं। हमारे देश में हुनर और कला का इतना भंडार है कि अभी से ही 300 से ज्यादा रजिस्टर्ड जीआईज हैं।
वाह नानी।
चल, अब तू चाय बनाने में मेरी मदद कर। एक बर्तन में पानी ले और उबालने के लिए रख।
यस बॉस।
पता है छोटू, तुझे मेरे हाथ की चाय इतनी पसंद क्यों है?
क्यों है नानी?
क्योंकि ये स्पेशल दार्जिलिंग की चाय है। ये देश की सबसे पहली रजिस्टर्ड जीआई है, जो 2004 में रजिस्टर्ड हुई थी।
लेकिन नानी, एक बात बताओ, इन जीआई से फायदा क्या होता है?
देखो छोटू, ज्यादातर जीआईज गांव के समुदाय के होते हैं। इनसे कारीगरों, बुनकरों, किसानों की आमदनी बढ़ती है। उनको अपनी मेहनत का सही दाम मिलता है और उन वस्तुओं की डिमांड भी बढ़ती है। साथ साथ खरीदने वालों को भी विश्वास हो जाता है कि वो एक जेन्युइन चीज खरीद रहे हैं।
ओह, वैसे नानी मुझे एक आइडिया आया है।
अरे वाह छोटू, तेरे को आइडिया?
यस नानी, अगले महीने फॉरेन से मेरे कुछ दोस्त आ रहे हैं। क्यों ना मैं उन्हें हमारे देश के कुछ सुंदर जीआई प्रोडक्ट्स गिफ्ट में दूं?
ये तो बहुत ही अच्छा आइडिया है छोटू। उन्हें ये चीजें जरूर पसंद आएंगी और हमारे देश की कला का नाम भी होगा।
देखा नानी, आपकी संगत में मैं कितना इंटेलिजेंट हो गया हूँ।
हाँ भाई, ये बात तो है।
और इस तरह एक बार फिर आईपी नानी ने आईपीआर का झंडा ऊंचा लहरा दिया।
So thank you for watching this video. I hope you must have liked this. This video had contained the entire aspects of GI, where the natural product and man-made products were shown. These are some of the GI that you can find out from here. That Darjeeling tea, then Makrana marble, Bobilli veena, Bastar dhokra, Venkatgiri saris, Madurai Malli, Jiraksal rice, then Surat Zari craft, Nilgiri tea, Darjeeling tea, Makrana marbles, Ratlami save, Kanchipuram silk, Katputlis of Rajasthan, Bagh prints of Madhya Pradesh, Bengal Patha Chitra, Sharial painting, and Bidri ware, Worli painting, Maghi pan, Devanhalli pomelo, Appi Mehdi mango, Kashmiri saffron, Shahi lychee of Bihar, Kurg orange. So you can see the different states covering the different forms of this geographical indications. So in this video we are going to see. Please watch. So thank you very much for watching this video. And as from the video, you can see that a boy is moving on the road and he's surrounded by all the forms of IPR. So you can realize the importance of intellectual property, where every human being is surrounded by the IP. So validity for patent is 20 years. For design is 10 years plus 5 years. Trademark is indefinitely subject to renewal. GI is indefinitely subject to renewal. Copyright is published literary, dramatic, artistic, and musical work. Lifetime of the author plus 60 years. Now, who can apply for all these IPRs? Person or individual. Not for an individual is not meant for any GI. Let me tell you, GI is a kind of community patent where the group of people, they are the applicant for filing any geographical indications. Any individual cannot file a GI application, or a legal representative person includes firm, partnership, small entity, and body corporate. And all IP rights are territorial in nature. Points to remember: first, protect, then publish. Rights are territorial, limited to boundary of country, sovereign authority. Registration is required in each country. Registration is done by sovereign authority, that is Government of India. Rights for a limited period of time. No automatic relief. Need to file infringement suit. Renewal fees to be paid from some IPRs. Appointment of patent agent is not compulsory. Applicant can sign the document and file himself. This is the last part is very much important because there are a lot of doubts inside an applicant and how to proceed with the application and how to file, how to write. So let me tell you, there are different forms available in our IP India site where you can find a document, patent document or design document or a trademark document, where you can yourself study and see how it has been filed. You don't need to take a help of a patent agent. You can file it yourself. Now, career opportunities. Career opportunities, you can get a government job, for example, examiner of patent and design, examiner of trademark and GI, examiner of copyrights. Now, other opportunities are like patent agent, trademark agent, GRF, SRF in patent facilitation centers, patent litigation, and other opportunities in private sectors. So these are the contact details, where the training center is at RG NIIPM Nagpur. You can contact that with the email ID and all the details. These details are also available into our IP India site. So let me, you can see the, I think it will take some time, find out the famous trademark from this table. At one go, it is difficult to find out, but let me give the answer. You see here Pepsi, then Link, then Cadbury, then Amul, Tata, Horlicks. So these are some of the brands, trademark brands. So find the IP here. There are 5 photographs here. So can anybody identify here what are the actual figure 1 is covering, 2, 3, 4, and 5? So answer lies here. First part contains the copyright. Second part contains the geographical indications. Third part patents, then design, and then trademark. So what protects the intellectual property created by fashion designers? This is the question. So what protects the advanced disc brake for the bike developed by the inventors? So these are technological inventions. So they will come under patent. Which of these is a geographical indication? BMW, Nagpur Orange, iron machine with stand, PlayStation, World Wide Web. Hopefully the answer is Nagpur Orange. All of you must agree with this. What does a trademark protect? An invention, a work of art, logos, names and brands, a secret formula. So logos, names and brands are covered under trademark. How long can a patent last? It is for 20 years. So these are some of the quizzes which you can yourself see. Imagine a cricketer set up his own company to sell his own range of clothes. What type of intellectual property can he use to show the clothes are made by his company? So will it be a part of copyright? Will it be a geographical indications, patent, designs, or trademark. So that, yeah, please.
Go ahead, please.
Okay. So these are quizzes just to educate over what we have seen over the slides. If a company develops a new technology that improves its main product, then what type of intellectual property can be used to stop others from copying their invention? So naturally, this will be under patent. So we have come up to the end of all the slides. So thank you very much. Thank you very much for your patient hearing. And I'm really thankful to Mr. Pranjal Barua and ICC that who have given me time to present and share my experience with all of you. So I would now expect some questions from your end. If anybody is interested to ask any question, please let me know.
Certainly. May I request delegates to kindly raise their questions? We are here. Very good. Thank you. This is your way, but you are
Yeah, my question was, you mentioned that these were limited to borders, right? So my question actually was, is actually for trademarks like logos and all of that, it really depends on, countries or different industries. But let's say you know more border, something which is more broad, something like like a market page or something, like constantly algorithm that you create and you use globally, how would you extend that?
Actually, I didn't hear anything from what this gentleman was speaking. You can repeat that question from your end itself. Can you do that? I didn't hear anything from that gentleman. Please.
Close your slide and we can have you on video. We can't see you actually. Can you close your slide and can you please share your screen? Yeah.
Exactly. Yes. That's a very tedious issue. So yeah.
Yeah. Now it's fine.
Can you hear me, sir?
Yeah. Please carry on. Please a little bit clarity should be there. Just use your phone a little bit to your mouth, near to your mouth. Yeah. Okay. Please. Okay.
Testing. Can you hear?
A little bit. Please speak out.
Can you hear me?
Yeah. Please carry on.
Okay. My question was, you did mention during your presentation that these were limited to borders, right?
Yeah. Sorry.
Were limited to borders, like one country, individual countries, right?
Individual. Your voice is breaking. Your voice is breaking.
Yeah, so if it's within the country, how do we, if you want to create something or you want to register something that is more global, how would we do that?
Okay. I got your question. You are asking that the patent and intellectual property rights are regional in nature, isn't it? So how you will get the protection worldwide? Is this your question? Okay. Let me answer that. All the intellectual property rights, they are regional and territorial in nature. So whatever the applications you are filing, that is valid and valid only in India, and the protection is given only in the Indian territory. Now, if you want to get the protection in US or in Canada or some other country outside India, you have to go individually into that country. For this part, there is a patent cooperation treaty where once you file a patent application in one country, you get the priority of that application in other country. That is the benefit. Suppose you file a patent application in US on 1st of January 2022, within 32 months, you can enter any country of the world, PCT contracting states, and there you can get the protection, but you have to enter it individually in each country. But the right is given territorially. You will get the right. If you file a patent application in US, you will get the territorial right in US and not in Canada or in India. So you have to enter in all the countries where you want the protection. Am I clear?
Yes, we have this answer. I think you were asking about some logo registration.
No, I was just clarifying this idea of logos. It could be with different industries or with different countries.
Right.
Yeah. Something more global like algorithm or something which is more expandable. Absolutely. That was my question. Adding my question.
Right, right. Any more questions, please? Can we have any more questions or probably from speakers? Yeah, please. Okay. We have a question from our MSME director.
I'm Tali Longjar, trained and MSME DIP.
Okay.
Sir, we have invented one product in Dimapur that is Bio Resource.
Yeah, sorry, please repeat that. Please repeat that.
Bio products.
Bioproducts.
No, bio products. Okay. That means Aero bio products.
What is that? What is that?
This is see when you are doing this one in our this one where human waste is producing and it goes to toilet. Okay. Yeah, engine we have invented there in Dimapur, but the intervener is not willing to do for patent registration. This is biodegradable products, and that will solve your human wastage, and water contamination was verified by this product. This is a liquid product. In India, only the solid product is available, and when we go for registration of these things, only the solid products NIC code is available. There is no NIC liquid products. When complaint is when I inquire about this one through James bottle also. But my question is, he can marketed his product, invented one, invention one, without patent right also.
See, as far as I got your question, that you are making something of the human facial product, isn't it? You are saying that only the solid waste was utilized, not the liquid waste. Is it the question?
Yeah.
Actually, I'm getting the breaked voice. I'm not able to hear it clearly. So Pranjal, I think you can ask the question from your end. What is that question? You please you repeat from your end. Please take his question at your end and then you tell me. Am I audible?
Yes, yes.
I think you should come to the dais. Just come to the dais and speak out, please. Yeah. That is good. Okay.
These products was invented by research page Galani University, who is a biotech, a specialized scientist there, and independent investors for developing these products. See, in our septic tank, when we were disposing our solid product, and it contaminates, and it is a problem for disposing the solid products, which contains in our septic tank. So, by the invention of this products, aerobio product, there is a micro bacteria there, which is using a minus degree also, and like Ladakh, Jammu and Kashmir, they have tested this product where there will be the army cantonment will be there, where they are using the septic tank and disposing our human fish. So it ultimately septic tank will become full, and we used to cesspool and cleaning all these things, and with disposes it contaminate our air, water, all these things are there. By invention of this aerobio, there is a micro bacteria there. All the bacteria will be existing in the minus degree also and plus degree also. There are so the all the solid products and purify the waters, condense. That's why it is highly demanded in railway when we are using this one in airline also. In India, from America, we are importing these products, solid products. But here, in Dimapur, one unit under, one independent under, he developed this through scientists, Kalani University of West Bengal. And now he is marketing, and we have a very good panel support to this entrepreneur from MSME Dimapur. And now he is supplying to all the municipal department in Nagaland and railway also. So he didn't want to have patent registration. I always advise him to do patent registration. He told me if his new invention is first he have to do a market, and he's invented some girls, so he will capture the revenue. Whatever is invested, after that he can give the dealerships all these things. So what my point is, we can sell without patent also. That is my question. Thank you.
Okay. See, getting, as far as I got your point, that getting a patent is a separate issue, and utilizing that social aspect of that human face is a different issue. Now you are saying that by use of the bacteria into the septic tanks, you are utilizing the waste product as a good material and then supplying it to the municipal corporations, isn't it? Is that the point? Is that the point?
I think probably some part is right. I mean, is there anyone who can explain it? Yeah.
Actually, I am not able to get the question. That is why I am not able to answer. So what actually is required? Is the device or the process you want to get it protection? Is this the idea?
No, the idea is whether the entrepreneur can market that liquid without patenting it.
Okay.
Can that product be marketed without the patent?
Okay.
I think he can market, but it will not be protected.
Right. So once that liquid which you are claiming, that might be marketed at your own level. But if you want to get the protection or commercial exploitation with that product, it will be difficult, because anybody can copy that your process and sell it to the market. If not in Dimapur or in Nagaland, but suppose that in Assam or some other state, then your invention or your effort will go useless.
Somebody else will replicate.
Yeah, somebody else. See, there is a term called trade secret. Now, let me give you an example. Like Pepsi and Coca-Cola, they have got a trade secret formula. They never went for any patent. Had they gone for a patent, their formula would have come to the public domain, and anybody would have used their chemical formula and made the Coca-Cola and Pepsi. But they never came for their product into the market by use of this patent instrument. So what they have done is they have gone through a trade secret. So trade secret, there is no legislation in India where the India government protects their trade secret. Okay. So it is very difficult to protect your invention which is under trade secret. If you hear the trade secret of Pepsi and Coca-Cola, you will be surprised to know that their chemical formula is kept in a vault in California, and no two people can come at the same time to find out the formula. They come from the different geographical locations. If they want to combine the formula, and then it is given separately to them. So no two person can know the formula at the same time. So can anybody in India have this kind of capacity to protect the formula? So that is why Indian people are told to go for the protection rather than the trade secret and anything else. Am I clear?
Any more questions? I think probably Mr. Parijati, thank you so much. Probably they have understood. And if anybody has any question, kindly mail it to us. That is pranjit.barua@indianchennai.net. And so we can share these questions to Mr. Parijat and we can get back to you. Thank you so much, Mr. Parijat, for your presence, and we'll definitely will be sharing with you with all the details with join today. Thank you so much, Mr. Parijat.
Thank you. Thank you, ICC and Mr. Pranjal. Thank you very much.
Thank you so much, sir. Now, moving ahead, we have Mr. P.K. Bakshi. He is the designated IP attorney from Indian Chamber of Commerce, which has the Intellectual Property Facilitation Center in Guwahati, which I was actually introducing when we were challenging against the internet. ICC also has this IPFC center in Guwahati, which is under the Ministry of MSME. So the reason why we are here, of course, one is under the Ministry of MSME, and the second is to create the awareness to use this facilitation center, which is in Guwahati, to use all the registrations regarding the IP under the IP, whether it's a trademark, GI, patent. So, Mr. Bakshi, thank you so much for here. We have, if you can showcase the camera, can I request can you just showcase the camera towards the audience? So we have the participants here. So his subject is on the legal aspects of IPR and how this ICC IPFC center work. So, Mr. Bakshi, are we audible to you?
Yes. Anjal, you are available.
Okay, thanks so much, Mr. Bakshi. Over to you.
Yeah, thank you very much, Anjal, and thank you very much, Indian Chamber of Commerce, for inviting me for today's this wonderful occasion of awareness campaign. And I can see that how wonderful people, nice gathering over there, that the people of Nagaland is taking interest on intellectual property rights. And today I feel really happy that such good dignitaries are present here in this meeting. And our previous honorable speaker has given us a very good lecture on the ins and outs of the intellectual property rights. Adding on to this, I would like to simply give some small ideas about the requirement of intellectual property. What is it? A small definition of it. So, like, in continuation, what is an intellectual property right? If we can get the actual idea and concept about intellectual property, the rest of the things are already clear. That is a trademark, copyright, patent, etc., etc. Okay. And what is an intellectual property right? Intellectual property, any property like your land, your building, certificates of education, these are all our properties, our individual property. Now, say for example, you are residing in a place with a plot of land which is not registered under you. Then you cannot claim that legal right upon your land. Any other person, any day, can come and say that this is my land, or I will reside over here, you please leave, which is not practically possible. But if the person will go to the court to challenge that the owner of this land is not the legal owner, I want to own this land, then there will be a matter of dispute. Now, to resolve this kind of dispute, one person must have a legal right upon its own property. This is called the property right. Right. Now, what is the word intellectual being incorporated into this right of property? The intellectual means any such thing which comes from the human intelligence. A piece of land is not the result of a human intelligence, but an invention, a product, a formula, or any such thing which is an invention or an innovation is has come from human intelligence. That is what that particular human intelligence must have a legal right, so that tomorrow any unscrupulous person or any trader or manufacturer cannot theft that particular invention, so as to the person who has actually invented that particular technology or that particular product or that particular brand shall get shall earn the monopoly upon his own business, upon his own commercial factors or aspects. In that way back in the year of 1700, 1600 in between, when there was European Industrial Revolution, the people who started doing various research upon industrial activities found that whatever they are doing, the inventive ideas, they are coming up with various kind of innovations and all, those are being taken out by some other person out of the industry and started earning revenue, and the person who has actually invented was not getting any royalty upon that, resulting the concept of intellectual property rights has been initiated by a group of industrialists way back around 200-300 years. So like that is the result of today's trademark registration, copyright certification, patent registration, etc. Under umbrella, there is an organization by the name of World Intellectual Property Organization based in Geneva. It has been situated in the year of 1947 and started governing this entire intellectual property fraternity globally. Whoever is the signatory of World Intellectual Property Organization, WIPO, is supposed to maintain the rules and regulations led by the WIPO, and accordingly various kind of acts has been introduced in the parliament of each country who are the signatories of the WIPO. Accordingly, in the year of 1932, the first Trademark Act was being introduced. Then in the year of 1956, it has been amended as Trade and Merchandise Act. Then in the year of 1999, it has become Trademark Act 1999. Our previous honorable speaker was talking about various categories of trademark, copyright, etc. So this is the concept of the trademark, the legal prosecution of the trademark. The act which governed the trademark system is Trademark Act 1999. This is for your knowledge also. And the rules how the trademark proceeding and its prosecution shall be governed, the rules being incorporated in the year of 2002 by the Ministry of Industries and Commerce under Controller General of Patent Design and Trademarks. Under Controller General, they have laid down a specific guideline which is being named as the Trademark Rules, which was incorporated in the year of 2002 and finally being amended. The last amended was happened in the year of 2017. So now, whatever the trademark proceedings and prosecutions are happening, those are happening under the guidelines of Trademark Rules 2017. Under that, first we will start talking from trademark, because This is the most popular practice of entire intellectual property rights. Trademark application is governed by Controller General of Patent Design and Trademarks, Government of India. Under this, the first procedure is filing an application. So when you will be filing an application for any registration of trademark, certain preventions, certain guidelines are being laid by the rules and the Trademark Act also. Please note down Trademark Act 1999. This is very important, and you can also Google the Act to learn more about various provisions and preventions of the Trademark Act. Under specific section of Trademark Act, under section 9 of Trademark Act, you can note down that also. Under section 9 of Trademark Act, it has said that any such mark which is customary in nature or commonly being used shall not be registered. This is important. That a mark, say for example, the name Nagaland, it is the property of the people of Nagaland. So somebody has named Nagaland tea, shall not be registered under Trademark Act. You cannot name such, you cannot take such names which is commonly being used, which is customary in nature. This is the very major prevention, and commonly we do this kind of mistakes at the time of selecting any brand. That is what the concept of intellectual property rights came in force. So the name Nagaland has got no specific exclusive intellectuality which has been invented by some person. It is the property of Naga. It is the property of the Naga people. That is what the name of the state called as Nagaland. It is not being invented by one single person. That is what no intellectual property rights can be claimed upon the name Nagaland. Nagaland tea or such kind of thing, which is customary in nature, cannot be registered. Number one. Then, number two, another prevention is if there is any such which is already on record of the registry. Say you have selected a name which is already registered in other part of the country, may not be registered. I will not say shall not be registered, but may not be registered. It may be registered in case if the trademark which has been adopted is well known in nature. Means if the trademark is already in operation, say in the state of Nagaland, you are already operating with a brand since last some couple of years, and after that you came to the trademark registry to file the application. The trademark registry may allow your application for registration under some certain circumstances, that you must prove that your brand is a well-known trademark by the provision of well-known trademark definition. Like you must have a good turnover of the brand. The brand must be well publicized in the market. People must know well. So there must be some kind of advertisements you might have done in the last period of your operation of the trademark. So some newspaper cuttings may be there, some local magazine advertisements may be there. Then your one dealer list will be very much helpful, because dealer list proves that the people in the relevant section know my brand. So that is what it can be considered as a well-known trademark. So these are certain circumstances under which a trademark may be registered. But if a trademark is customary in nature, if a trademark is devoid of distinctive character, that is to say, not capable of distinguishing itself from any other person or any other system, you must have a distinctive character at the time of selecting your brand, which reflects your intellectuality. Then only a trademark can be registered. That is one part. Now coming on to, if a trademark being infringed or passed off by some other person in the market, what are the remedies being given in Trademark Act? Under Trademark Act, you can file a civil suit in any district civil court in your area. And that is the civil remedy, under which if you win the case, ultimately the infringement has been proved, then a person may be fined as per your prayer, considering your goodwill and turnover of the brand. This is a very good remedy being prescribed in the Trademark Act. Along with this, you can also file a criminal suit against that particular unscrupulous trader. You can file a FIR not below the rank of Deputy Superintendent of Police. It's a very serious offense. If you file such kind of FIR before any DSP, the DSP will do a search and seizure without any warrant to the accused person. And this is this is a very strong protection being given to the registered owner of a brand. And the factory or the manufacturing area or the trading area of that particular trader shall be seized till the time of final disposal of the case. And he may be fined not he may be fined with an imprisonment of 6 months along with a fine of 50,000 rupees plus compensation, which may be extended up to 1 year with a fine of rupees 2 lakh along with compensation. So these are very strong protection being given under Trademark Act. Accordingly, in Copyright Act, in Patent Act, in Geographical Indication Act, similar kind of protections has been given. So you can just Google sometime whenever, if you will get a very keen interest upon intellectual property rights, you can well understand those, that what are the provisions and protections being given, what are the legal enforcement being prescribed by the relevant act, and you can come to know. These are very, there is no such kind of rocket science to understand the language of the act and its provision. Now coming on to the ICC's governance. Here in Northeast, we set up Intellectual Property Facilitation Center, that is IPFC, under Ministry of MSME, where we are facilitating all the applicants who are coming to us for filing of application, for guidance, or to draft any application for trademark, copyright, or patent. And there are various other technicalities also, which in due course, if you file an application, you will practically come to know. Here, the most important benefits are, number one, we are locally available. You are not required to go to Kolkata or Delhi or Bombay for your facility purposes. You will get everything here at Guwahati. You can come down anytime at our IPFC center set up at ICC in Ganesh Gudi area of Guwahati, where we are always available in any weekdays to help you out, that how to file, what to file, and you will get all the guidances before selecting your innovation, that whether the innovation is practically possible to get registered or not. We will give all the consultancies over there free of cost. There is no separate consultancy fees being charged. It is the proposal from the MSME. So we are giving you all those facilities. That is number one. Number two, coming on to the main factor of expenditures, the fee structures are designed by the government in such a way that it should not be a burden to the applicant. We are charging a very nominal fee, just cost to cost, so that you can be able to file more and more applications for patent, for trademark, for copyright, etc., so that we can we can offer more facilities to the applicants, to the aspirants. That is one thing. Along with, MSME is also having one scheme that for trademark or for patent, you can also avail subsidy from MSME after filing the application. Whatever the expenditures you will incur, those will be subsidized. May not be 100%. There is a specific threshold that is for trademark. Certain amount shall be given, and for copyright, for patent also up to certain amount shall be given. Which Mr. Pranjal is the right person to give you some more ideas upon this. So that is all about the facilitation center of Guwahati, which is covering the entire Northeast. And I think that we have already done some MOUs with the government agencies, industries and commerce ministries, other universities also. So we are requesting all of you people to come forward to join hand with us, so that we can give you more and more facilities. And we are always available here to any kind of vocabularical ideas, to give you the grammatical ideas about intellectual property rights, its prosecutional factors. And if any of you are already registered under any of the categories of intellectual property, and you are seeking any legal protection, you are seeking any enforcement of your IP rights, you are most welcome. You can immediately contact our ICC, IPFC here in Guwahati, and we are readily available to give you those services at your doorstep anytime. So that is all about my discussions for today. Thank you very much, Pranjal. Thank you very much, everyone, for patiently listening to me. You can ask any question about the enforcement, about the legal rights of IP if you want. I'm right now available to answer all the questions. Over to Pranjal.
Thank you so much, Mr. Bakshi. Can we have any questions from the audience side? If you have any queries, I think, yeah. So can you? Okay, we are interested in talking about this. You can come with.
Yeah, I want to talk here. Question relating to publication. Can a publisher?
Network.
Hello.
Hello. Yes. So you are audible. Sir, you are not well audible.
Can you come to the podium, please? So that can you switch off the mic? No. Okay, let me, sorry, so can I have your good name, please? Mr. Tamjan. Okay. If Mr. Tamjan, he has a question, can a publisher or an author who is not registered under IPR Act sue against a person with
who reduce or reprint or use a part of his or her article without consent.
Is it audible to you, Mr. Bakshi?
No, it's not audible. Pranjal, do one thing, give me a call. Over phone, I will take that question.
I'm sending, sir. Can you open your WhatsApp? I'm sending you this
please.
photograph. Yeah, that would be a most easiest way.
Yes.
Yeah, I'll send this note, this question to your WhatsApp. Can you read that?
Can a publisher or author who is not registered under IPR Act sue against a person who proposed, or what is who
reproduce or representing
or used a part of his or her article without consent. Yes, of course, of course. Absolutely. This is an act of passing off. This is absolute an act of passing off. Because you are unregistered, this will not be considered as an act of infringement, but it is an act of passing off. Without your consent, if even an unregistered work being copied by somebody without the consent, it can be well prosecuted under IPR laws. Yes, absolutely. In this connection, it's a very good question, Pranjal. I must thank the attendee that I would like to mention here that a copyright registration is not mandatory. If you are having any such kind of literary work, artistic work, dramatic work, software, or even websites which is being designed by you, and you are having the absolute proof of all your works, you are eligible to file any kind of IP suits against the latter. Absolutely.
Right, sir. Yeah, we have one portion from the Commissioner and Secretary in the conclusion to that. Okay, do this right extend to the death of author, basically, on that author. Suppose
If he's not,
okay,
if he's not copyrighted.
if it's not copyrighted.
Which one? Which one?
I mean, if the author, suppose after his demise, and his content is not copyrighted, can it be?
No, see, even if it is not copyrighted,
after its demise.
After its demise, okay. No, after demise, the copyright is applicable up to 60 years. From the date of demise, the copyright is applicable up to 60 years. Hence, if the tenure is not over, then the legal right can be enforced.
If it is not copyrighted.
Even if it is not copyrighted, as I said, copyright registration is not mandatory. Just it must have a proof that the content is owned by the complainant.
Is that 60 years counted from the date?
Is that 60 years counted from the death of the author or the person, or when? I mean, the 60 years counted from which date?
From the demise of 60 years, the date of demise of the author.
Okay. Right. Anything? Can we, sir, if you have any questions, if you have any doubts, Madam?
So, in research work, one quotes without taking permission from the author, but knowledge always in the bibliography. So, is that okay?
Just a moment, probably.
Regarding copywriting, in research work, one intends to quote from a published work, but credit is always given at the end of the book. Is that okay?
Sorry, the last part I couldn't understand well.
Credit is given to the person who's already written the book and you have quoted him or her extensively in your research work.
Still, it is not clear to me. Pranjal, please WhatsApp the exact thing.
I should be spending the whole afternoon doing that.
Okay, what I'll do it, let's just quickly type this question.
Please.
I'm doing research work, after publication of the books, I'm getting the.
I'm quoting something from a published work.
Yeah.
Right? Will I be liable for infringement?
Yeah.
Okay, the question is, after the publication.
After the
After the publication.
after the publication, okay.
After the publication, will he or she will.
If I quote
Okay.
something from that published work.
Oh, okay. If you, I mean the same person. Yeah, someone else will quote. And not any infringement against that publication.
Even after publication also, yes. Even after publication also, legal right can be enforced.
Okay.
But that's very pertinent because you see.
Yeah, please.
Dr. Kanga, you.
Okay, if you can use a little copy from here, you can.
Okay. Dr. Clark, you say. I don't know, I'm right. Yeah, good afternoon.
Yes.
Madam is saying, am I audible to you?
Yes.
I think
When doing research work, we used to cite certain authors, right? So Madam is asking, after publication, the person who has done the research work, by citing some other's work, after publication, will that person will be liable for infringement?
No.
I think.
No, not at all. Citing someone's example or citing some cases, citing some other works and all is not fall under the definition of infringement. No, that is just taking the reference of the other similar kind of matters.
When citing the articles itself, then there are certain rules for copyrights, right? Like they might have given copyright for citing and all. In that order, we have to cite. So we can use it. There is no.
If you write courtesy to that particular author from where the article has been cited, that doesn't fall under the infringement factor.
Right, ma'am?
Thank you so much. Right. Any more questions? Or should we end with the session? Right, sir. Thank you so much, Mr. Bakshi, for your presence.
Thank you.
And I'm sure we have learned a lot of things from you also and from other speakers. Thank you so much once again, Mr. Bakshi.
Thank you, everyone.
Now, with this, after this interactive session with the delegates, now we are going to sum up, and with the vote of thanks, I would like to initiate. I would like to thank the Ministry of MSME, Nagaland, to giving us this opportunity. This is basically a series of workshops, a summit which we are doing in Nagaland, starting with the National Conference on Intellectual Property Rights, which we have done today. Tomorrow we have another conference on analyzing MSME in international trade. So basically, this conference has been divided into three sections. One is on MSME financing, which has various schemes from the financial institutions. Secondly, the customs rules and regulations and the procedure for getting IEC codes. And the third segment is GST, where all the officials are joining us on physical and virtual mode. This conference will be taken care of by ICC along with MSMEDI and the support of Government of Nagaland, of course, especially the Department of Industries and Commerce. The location, the venue will be at Hotel Saranati, and the time is from 10 in the morning. So I would request you To all, this is also another important conference which we are having tomorrow. Please join us. And the third conference that is on GEM, Government E-Marketplace. This is another very important step which we are trying to put up in Kohima, Hotel Jafu, on 31st of January. The timing is the same from 10 a.m. onwards. So if you can try to come out from your busy schedules, please join us there also on 31st January. With this, I would like to extend again my thanks to MSMDI for giving us this opportunity. I would also like to extend a thank you to Department of Industries and Commerce from Government of Nagaland for believing on us and giving us the support and allowing us in this situation to host these important subjects. We would also like to extend our thanks to the media person who are here since morning to cover the entire event so we can reach out to the maximum level of people in Nagaland. With this, of course, most importantly, I would like to extend our thanks to Shri Jusa, Commissioner and Secretary, who's from Department of Industries and Commerce, Government of Nagaland, who's here since morning. Thank you so much, sir, for taking out your time from your busy schedule. We are hoping you for 28 and 31st also, if we can have you. Thank you so much, sir. We would like to extend our thanks to Srimati Sentla Yanga. She's Padma Shri awardee, also the founder of Tribal Week and the chairperson of ICC Northeast Handlooms and Handicraft community member. I'd like to extend my thanks to Mr. Nandover Ketan. He's executive member from Business Association of Nagas. He's also known as BAN Dimapu Nagaland. Thanks to special thanks to again Mr. Tali Nauta, the Joint Director, Head of Operation from MSME DI Dimapu Nagaland Ministry of MSME and Government of India. Thank you so much for giving us the recommendations to host such important sector in Nagaland, and we believe we will keep doing and do more research on what we can do here in Nagaland to create awareness. We would also like to extend a thanks to Dr. E. Ganga, Assistant Professor, Innovation Ambassador from Ministry of Education and IT Nagaland, who has covered the subject on technology development and introduction to future growth. Thank you so much for your presence once again, and we are hoping that we will be very soon signing the MOU with NIT Nagaland on 28. Apart from that, we have two very important panelists. Mr. Parijat Saurav, he is the Deputy Controller and Deputy Controller of Patent and Design from Office of Controller General of Patents, Design and Trademarks from Kolkata. Thank you so much for joining us virtually. We'd like to also thank to Mr. P.K. Bakshi. He's a designated IP from Indian Chamber of Commerce from the Intellectual Property Presentation Center. Thank you so much, sir. With this, we again would like to extend special thanks to each and everyone for joining us this morning. Thank you for your patience. And now, with this, we are ending this session. And we request you to let's proceed with the lunch. Thank you so much, everyone.